Well, I am for the one of the district primary school council. It's about A category scale of pay. Now, candidates from 5 district, Malad.
Different district, different council, all are different.
Now, Nodia, Murshidabad, Purulia, South 24 programs.
Two players is here. One is Malad. They are not giving us the B.Ed certificate. DLED certificate. Sorry.
Who will provide you?
Malad, regional director NIOS. That is
Regional director,
respondent
they are
number.
not. Come separately. Come separately.
Malad lordship only
Withdraw it. Otherwise, I will dismiss on merit. You are entitled to, but it is difficult for the court and difficult for them to deal with it. So why are you clubbing? Are you enjoying it?
Malad, only one player, maybe only one player.
For one pair?
No, for one. Petition number one, maybe.
No, not in this way.
Only others maybe.
No, come separately. Come separately. Please come separately. Separate cause of action, separate pay scale, separate district primary school council. How can you club it together?
A pay scale is same.
But
All are
different
accessible.
district primary school
It is
council.
correct, separate district.
You understand? You understand? Different district, they are together. This is a cumbrous. You are making it cumbrous. Petitioners are entitled to, but for this action, they are not.
And relief is
Withdraw
to be
it,
given
file
by
it.
the jurisdictional
I don't mind in taking 300 applications one by one. But please make it separate.
Respondent number.
File it immediately, it will be listed. Withdraw it. Withdraw it.
Only one thing, Malad. Director of National Institute of Open Schooling, they will issue B.Ed certificate. A category teacher.
DLED, well, that,
DLED.
that will not go in favor of the petitioner. They are entitled to, but prayer is for direction upon the NIOS to issue the DLED certificate. What will, purpose will be served, I don't know.
NIOS, how will this up? Because since you have completed NIOS, judgment, Devesh Kumar, na?
Yes,
Devesh Sharma.
NC.
So you have to complete the course.
We have completed.
Actually,
No.
Higher secondary completed. With
no, DLED.
DLED completed.
From NIOS. The Supreme Court has said that Supreme Court has said that you have to your job will not be taken, but you have to complete a bridge course within a certain time. That course has not yet been designed.
Well, I think,
Withdraw it. Please
I think
withdraw it. Please withdraw it. Ashun.
not clear certificate.
Technical proposed rule for the issuance of the appointment letter and the confirmation certificate.
The one which I had handed up.
Exactly. Regarding the confirmation, it is my opinion or my feeling that if you keep this deemed provision, it may dilute the whole exercise. Because it is a nicely framed rule, but the B, last, the report of the service school is not considered and disposed of by council within a period of 3 months from the date of receipt of the letter.
Deemed.
The deemed clause may dilute the exercise. Because why? Why this? Because they are teachers.
No, I
Their
get you.
performance to be ascertained first. On the contrary, you consider whether, like some services I have found, that the applicant or the teacher, after completion of 2 years on their own in a prescribed form, will apply to their SI. That will be verified by the school with the attendance, with the performance column, certified by them. it will be deposited on their motion. If it is submitted with the SI, and the SI will verify it with the correspondent, and then it send it to the council. So a task on the teacher that after completion of your 2 years of service in a prescribed form, you apply to the SI, giving some details, your performance details, your attendance details to be certified by the head teacher of the school and the SI. All this, how much leave you have taken in that period. All these, whether a column, whether any case is pending or not, it is you to decide. If it is relatable to his service, then it may. Whether any disciplinary proceeding is pending against you or not, whether it can be done or not, kindly consider this
Well,
deep
One is the deemed part to be removed,
part.
and the other is to lay down a procedure that the teacher concerned through the head of the
Right.
institution will forward relevant details.
Details in a prescribed form, in an application. Kindly consider that aspect. That deemed provision, that is why I have asked you.
Very
Thank you.
well. I'm grateful.
Thank you.
কাউন্সিলে ভাই কি সাসপেনশন কিংবা আমার নিজে বলতে 22 জন সাসপেনশন 10,500 টিএর মধ্যে 22 জন সাসপেনশন
What lordship, your lordship, that lordship, head of the institution, if the lordship filled up the form, that is
No,
the,
no, no.
what is the procedure?
Certified.
Certain, that is the lordship. Very lordship, that,
Otherwise, what will happen? After 2 years, automatically.
yes, sir.
He goes to the school or doesn't go to the school. After 2 years, I am a teacher, full-fledged teacher. Thank you, Mr.
Very well.
Dotto.
I'm grateful.
And for the state.
But perhaps this is a unique situation with your lordship, because it's about mutual transfer between persons, and it's more an inter-district transfer. Now, this is the second round of litigation. The first order was passed in page 36, order dated 7th of October 2024. Your lordship got it at page 36.
Hmm.
Now, there is a direction upon the board to consider this case. Relevant portion at page paragraph 3 at page 37.
Page 37.
Page 37, paragraph 3.
Hmm.
Now they have considered, and page 38 is their reasoned decision.
Hmm.
Now reasonings that are appearing from page 39. And may I read it from Alot? Paragraph 5, page 39. In Rule 8 of the West Bengal Primary Education Transfer of Teachers, including Head Teacher Rules 2002, it is stated that in case of inter-council transfer, the council shall follow the principles and procedures of
Again wrong. Again wrong. This is no longer after the amendment of 2021. Board. See, then
now this said the next, my lord, in the amendment of West Bengal Education Transfer so and so dated by 13th of September 2021.
21 taken care of.
Taken care of. Now for Rule 8, it substitutes as while considering inter-council transfer in accordance with the provisions of clause K of section 19(1) of the Act, the board shall mutatis mutandi follow the provisions of these rules, particularly sub-rule 3 of Rule 5 of the rules, provided that the board may on basis of application or otherwise transfer any female teacher who is victim of crime with the concurrence of the state government in the school education department. It shall maintain due confidentiality in regarding identity of such victim. Now, my lord, it's about implementation of Vishakha's judgment, if I am not wrong.
How it comes here?
What they are describing, what is their power, what they can do.
What is the relevancy of this discussion?
They say only in this case, inter-district transfer may be taken care of. And they said there is a dearth or there is more silence about this 3% transfer mutually.
Wait. Cases direction movement has to be, then they are talking about that SOP. What they have framed only is under challenge. Now the under such circumstances, the analogous issue for the secondary has been dealt.
Now they are relying on, my lord, secondary education. Since primary education is, my lord, silent.
But here the
Not
price.
Now the basic difference is that in secondary education there are various kind of posts.
But why is importing this? Why are you importing the secondary analogy?
This thing was inputted over here because the three.
Why you are bringing it? Are you authorized to bring it? Tell me clearly that we can, to fill up the vacuum. There may be a vacuum. We can lay our hand over the secondary rules. Are you? Can you?
No.
First of all, they in one case I have found that under the direction of the board, all DPSCs have created a SOP, which is dehorsed the rules, contrary to rule. It will go. Now, what you have in your hand, you have the 2002 rules in your hand, and 19K your general power, and the principle and procedures are no more applicable after the 2021 amendment. 2021 says this rule, this one, in notwithstanding sub rule 3 of 1, exclusion of the within council transfer between two council, the procedure prescribed under 2002 rules amended up to 2021 will apply mutatis in respect of the transfer of the teachers in between two districts. So you find out, you confine yourself within that. Find out where is the difficulty in entertaining if three teachers comes together and say we want the mutual
A will
transfer.
be placed by B, B by C, C by A.
This way.
Yes.
We have received 4 also.
No, in this way, your main consideration would be subject to what you people say, that whether it will affect the school in any manner whatsoever. In any manner, you may decline. I don't know about rules interpretation, forget about that. If I place you there, the children will
Let them
suffer.
take a practical approach before lordship.
Where is that?
So you kindly take this up matter a few days after, because the transfer matter also has fixed those two matters. Yesterday it was taken up. Mr. Sharma is addressing regarding 202 2002 rules, 21 gazette, everything, lordship. Let that be decided.
Why people make unnecessary complication? Why?
And in this respect, about this reason, not
I don't know, because of the too much court cases, the board is also interested to go into the interpretation of the rules and everything, instead of concentrating how the education can be improved.
In some doctor's chamber, there is a quote nowadays. Keep your Google obtained knowledge outside of this room and then enter.
No, this is, I have seen that this law attracts many people. I found some doctors, they are very interested in, and nowadays for this ওইটা আর লিখতে হবে না মাঝখানটাতে।
Because I was waiting for the because server is not functioning. The postal
ওইটাই কালকে কতগুলো সার্ভার ওগুলো ফাইল করেছিল
Lastly, the
পরে।
postal department is disturbing last 3-4 days.
This is not default. দেখি কে করেছে কি মামলা? করছে না কেন? This is not default. 14.
identical like 12. Identical, madam.
I'm appealing for the state.
PPR is mutual transfer.
Yes, madam.
No, recent order passed that
That
report
between the
should fall-
three persons, madam.
because the
Identical,
paragraphs are
like-
almost same.
Like 12, but almost not identical. Identical.
But I'm appealing for the state respondent.
Get a report from the commissioner.
Madam.
Where is the order impugned?
So that is at
Page 35.
identical order.
2012 rules.
Yes, madam.
Possibly he cannot.
Madam.
আসুন ওই সিমিলার অর্ডারটা করে দিন। ডেটটা what is the order date? Impugned order date? Same date.
Its order date is of 17.
No, that was 25th January.
25th
January
17th
না
January.
January না?
আগেরটা কত তারিখ ছিল?
17
17 ছিল।
17 January.
17th January. Get a report from the commissioner of school education.
Well, there are three petitioners, my lord. Court fees ought to have been paid in respect of other two.
Deficit court fees to be paid. Petitioner is required to pay deficit court fees. আগেরটা পেমেন্ট ছিল?
আগেরটা কত ছিল?
April month.
12
ছিল না? পেমেন্ট ছিল না? Ask Mr. Sarwar Jan
12, item number 12.
due to the deficit court fees. Within a week from date করবে না?
না রেকর্ডে তো
Deficit court fees is petitioner is required to make good of the deficit court fees within a week from date. Ask Mr. Sarwar Jahan.
Lordship, record my seniority. এখন তো রেকর্ডে তুমি করেছো।
Where is your senior?
No, not my senior. Item number 12.
I am also appearing.
Well, item number 15. My lord, Mr.
Which
Deepak-
one?
Item number 15, my lord.
15 lots is
The learned advocate, Mr. Dipan Kundu is appearing on this matter, my lord, but unfortunately he is very ill today, my lord. Kindly please adjourn the matter for just today.
Out of list. Prayer made, accommodation. Out of list, liberty to mention. 16.
16
Ah, senior.
like 12. Order
Malad
17
appearing for the
January.
state.
Order is of 17 January.
সুমন্ত ধীরে ধীরে করে নাও। ধীরে ধীরে করে নাও।
হ্যাঁ তিনজন deficit court fees
You know, all the deficit court.
all matters.
Within a week you have to pay, but get this affidavit of service. 17.
A similar matter.
Identical, same day, 17 January.
Very well. সুমন্ত হয়ে গেলে বলবে। এগুলো এভিডেভিট অফ সার্ভিস আসলে তারপর আমাকে সই করতে পাঠাবো।
না এটা
17th ছিল
18 I appear for the petitioner.
I am appearing on behalf of the estate.
The Howrah DPSC matter 2009. Lordship.
For the timing, out of list.
Lordship.
Out of list. Let the matter go out of list, liberty to mention. Evidence of service file.
It has been solved, but due to the difficulty.
Very well, very well, very well. Don't sub now, out of list.
my lord item
Grateful, Lordship.
my lord item 70 my lord has disposed it of because there is a rejection order in mutual
No. 17, I have asked
yes
the commissioner to file a report as to whether
Hmm.
the board can rely on the secondary rules to reject the prayer of the petitioners.
yes 3% is seeking my lord
That is unsafe. There is no bar in your
Yes.
rules.
right I'm getting
Out of
Lordship, 18 and 19 both similar matter. Howrah DPSC 2000.
Out of list, out of list.
My liberty to mention.
My lord, in 19, I am appealing for state, my lord.
Yes, my lord.
Yes. Give your appearance 20.
For the state.
এটা 20
এদিক দিয়ে গন্ডগোল হয়ে যাবে।
No, I'm for the petitioners. No, the petitioner was appointed as a Swahika in respect of Sisuka Kendra in 2002. Now, she has retired in the from the post on 31st March 2024. Now, kindly see the 2016 circular page 17.
So in this matter, Paschim Bongo Rajya Shishika Mission is the competent authority to answer. Mr. Jan is appearing. Because all Sahayikas are under the Paschim Bongo Rajya Shishika Mission.
Why are you challenging this memo? Page 90.
No, but that's why the circular has been given effect from 1st April 2024. Kindly see that.
Hmm.
Now, my lord, my client has retired on 31st March 2024. Now, what I am telling to you, Lordship, this is why the discrimination. Because the Swahika will be working after
It is finance department.
Decision, a policy decision on the government.
policy decision must be reasonable.
Everybody will
Not
come.
discriminatory and arbitrary. Because you
It is
Lordship,
the arbitrary
let me
interest.
make my submission. Because I tell you, Lordship, the Swahika who will be retiring before 1st April, they will not get any extended benefit. And the Swahika will be working after 1st April, they will be getting extended benefit. Why? Nature of work same, eligibility criteria same. What such sort of discrimination or
According to what should be the cut-off date, it should be given effect to from which date?
no? This fresh circular has to be issued extending the benefit to all these employees who are working in the similar nature.
No. You have already retired
I am retired.
with effect from 1st April. According
No, I have
to
retired 31st March.
you retired 31st March 24. One may retire in 31st March 2018. One may retire in 31st March
That
2017.
means,
Huh?
that means.
So what will be the, where which will be the cut-off date?
Cut-off.
The cut-off date, that's why
Suggest anything.
to issue a fresh circular extending these benefits to all the Swahika because the nature of work is the same.
All these who has retired,
Huh?
everyone
Because they will not be discriminated.
who has died.
No, that's another question. Why not?
Yes, will come
Because my lord, who has died?
because a one-time at 5 lakh
Yes,
enhanced to 5 lakh
yes,
from 2 lakh,
yes.
3 lakh. On
And
what
this
existing-
extended benefit will be available to those Swahika who will be working after 1st April 2024. That's what that
the state.
I am for the state, my lord.
Hey, answer his query.
My lord, there is no discrepancy. My lord, it is a totally policy decision of the government. Government decided that the two 2 lakhs to 5 lakhs or 3 lakhs to 5 lakhs. Those who are opted 60 years, they are entitled.
No, don't say the fact.
The
He
fact
is
is, my lord,
that this is a discrimination. Whether this is a
no,
discrimination.
my lord, this is no, but this is the policy decision of the government. My lord, whether the writ of mandamus, I am putting question myself, whether writ of mandamus can be issued on the where the government took a policy decision.
Where is
or not.
Mr. Jahan?
He's saying is in code number.
He has not been implemented as party. পশ্চিমবঙ্গ যাদের আন্ডারে কাজ করে পশ্চিমবঙ্গ রাজ্য
Circular
So,
issue, can you see?
yes, yes.
You have to engage.
By the deputy secretary.
But you are an employee under the Paschim Bongo.
Since the circular is under change, that's why he has been made a part.
He is the authority under which
You
the
are saying 31st
also
March. I have to ascertain from them.
then, my lord, I have to file my lord affidavit.
Not affidavit. I should not keep it. Tell me, yes.
Only one thing, my lord. The same point was cropped up before the Supreme Court. Point one. Now, what happened, I told last year, the appellant before the Supreme Court was working in a savings deposit fund for the purpose of Air Force. Now, the employee who are working in the Air Force, they are the government employee, but those employees who are appointed in the savings deposit fund, they are not the permanent temporary employee, but work is the same, nature of work is the same, eligibility is the same. Now, sixth pay commission has come into effect. So the pensionary benefit has been given to those employees who are working in the office, not those employees who are working in the Supreme Court said this policy cannot be. You cannot discriminate this. Totally opposite. Can you see the paragraph 33, 34, 35, 36? Supreme Court report. ACR 2024, volume 8, ACR.
2024
Volume 8, Supreme Court report.
volume 8
ACR, Supreme Court report.
SCR to volume 8
Supreme Court report লিখেছো?
হ্যাঁ। and nature of work of the all soikas are contractual.
State party বলছে আপনি স্টেটের হইতো
কেউ তো পার্টি করে
তো কোন ডাইরেকশন দিয়ে
Have you noticed that this has been shall not form a precedent? Shall not form a precedent. So as to have detrimental effect to the financial health of SSD fund. This will impact the state fund hugely. If I accept your contention, particularly two facts were taken into consideration while directing this, that it is relevant to note the appellant's batch seems to be the last in their genre of SSD fund temporary employees. These are the last batch. Therefore, no financial effect would be there in the SSD fund. So also that is how, and again it was that it shall not form. The result to the appellant shall not form part. The direction to extend the benefits of 6 CPC and the RP rules to the appellant shall not form a precedent so as to have a detrimental effect. So this is, in the facts of the case, is different.
Facts of this case is not the different because they are the temporary employee, they are the permanent employee. So CISPay commission beneficiary benefit has been given to the
Facts are different, sir. Facts are different. You may say that nature of job which we have done, maybe a permanent employee is doing the same thing, but you accepted a contractual appointment which you up to age of 60, renewable up to age of 60, you have retired. After your retirement, a college took a policy that instead of 2 lakh, 3 lakh, the one-time monetary benefit should be extended to 5 lakh. That much, that far. If it is this, there is no cut-off date. Government thought it expedient. There must be, this should be given from 1st April 2024. Now you are saying it should be given back since I have, it is 31st March. It should have been given.
2016, the government policy was adopted that the only 1 lakh benefit has to be given to those employees, and effect has been given from 2013. Now, my lord, that was again, my lord, the 7th April 2024, that benefit was extended to the 5 lakhs. But my submission is
No, not 5 lakh. From 2 lakh to 5
2
lakh
lakh,
done on from 4th July with effect from 1st April.
my submission is that
Why 1st April? Because it is the starting point of a financial year.
no, my point,
It was justified.
my point is that because 1st April, what is the basis? What is the reason? But kindly say there is no reason to that
Financial
extent.
year, sir, financial year.
Financial year, but why this benefit has been given 5 lakh, 2 lakhs to 5 lakh? This reason has not been mentioned. Kindly see what is the reason for that?
Because
And another thing, another thing. You also know the state of Punjab versus Jagdish Singh judgment. Equal pay for equal work, and the retirement benefit has to be given equally to those employees who are working the similar nature. This judgment will not state of I have brought this judgment.
No, he has got no relevance.
my lord.
No, he has not made party, not necessary now. 21. A judgment. Hey, Mr. Doctor, judgment, let it be judgment.
Hello?
Judgment after quoting, I will return. You have cited it. The judgment will be in the record.
Oh.
21.
21 my lord, I am for the petitioner.
What is this?
My lord, there's a petitioner wants to refund the amount in terms of rupa 1990. দিয়ে দিন একটু just
বলো সিপিএফ অ্যামাউন্ট
yes.
বড় কাউন্সিলরে এই হয় সহজ কথাটা সহজভাবে বুঝতে হবে সহজ কথাটা সহজভাবে বুঝতে হবে নাম দিই আমাদের কুড়ি একুশ দুটো কুড়ি দিয়ে দিয়েছি
Vice টাকা
22. Well, I am appearing on behalf of the state bank.
Lordship, Mrs. Kutia, Mrs. Shobita Kutia, my lord, is appearing for the petition, my lord. A 10 minute short passover, she is on her way, my lord. I have been instructed to ask for a short passover.
There is a shortfall of service, my lord. My lord, I am covered by the division bench judgment.
Shortfall of qualifying service.
Yes. 7 months, 17 days.
7 months,
17
6 months is condonable.
Yes. It is 7 months, my lord, and now I am covered by the division bench judgment. My lord, division bench Abdul Jabbar case. Here, the division bench held that the court cannot pass any order beyond the scope of the statute.
Justice Tandon's order,
Yes, yes.
but Justice Sen's order is otherwise.
Different divergent views are there.
Whether, my lord, but I do not know, my lord, what is the fact of the case. If there is any delay in appointment or she is there in other service, this has to be looked into because Abdul Jabbar, I have appeared in the matter.
Very well.
By 22, 23, 24, only 10 minutes possible, my lord.
Or the lordship can fix it any other.
10 minutes
Very
is come.
difficult. Accommodation paid for next monthly list করে দিন। Not this week রেখে দাও বুঝলে তাহলে automatically
She is coming, my lord, if only, my lord. ঠিক আছে মানে
March it will be top on the March.
Yes, I am getting
22, 23,
24.
25.
24 বলে দিয়েছি 24
All are not this week because petitioner is not available.
25 dates are in service candidates. But I have annexed the last order passed by my lord in identical matter.
Let it be in the monthly to April lordship. In the meantime, I am communicating there.
Page 320, my lord.
দাও file দাও। So there is no issue in keeping it pending.
No, my lord, my lord has been pleased
They
to
will give it. Page
320, my lord, last annexure, my lord.
কতগুলো পিটিশন আছে
100 কত
ইজ কোর্ট ফিস
কোর্ট ফিস আমি কোর্ট ফিস করে দিই
you will supply it. Why should I keep it pending?
Lordship, if the data are there, means all the documents that he has already provided, we are giving them data.
Necessary, I will ask them to provide it to you.
If not, lordship, we are in our website a corrigendum has been published that this candidate are not having the documents. Supply us the documents. We are notifying in the website also.
treated as lokesh de, it will be allokesh de. Leave may be granted to correct the necessary.
একদম বলে লেখো leave is granted to the learned advocate on record for the petitioner to correct the name of the petitioner number 3
Grateful.
by amending the cause title of the petition.
But I've handed over the receipt of depositing the court fees, my lord.
না cause title of the amending code of the in the cause title of the writ petition.
Grateful.
Then next one.
Next one মানে এই ক্যাটাগরি মালদা ক্যাটাগরি মালদা 26
হ্যাঁ
একটু দেখাও না এই অর্ডারটা কি একটু বলছি কোর্ট এটা নেবেন দাদা
At 27 also, my lord, to
For
take
the board
certificate,
also.
my lord.
I'm for the state.
Similar to, I think, 26.
25.
25.
So,
Similar to 25.
pronunciation.
No correction नहीं दिले.
পঁচিশটা একদম কপি করে দাও item 20
Only, my lord, leave part is not. Only that leave has been granted by
Correction
my
is there in the cost.
লিভটা বাদ দিয়ে 25 এ লিভ
I'm for the state response.
time for that petitioner is working as a primary teacher.
that same issue na
Same issue, but not focus.
Order 15,
Intra.
page 50.
Intra.
Not
No, no.
ওই যে কাউন্সিল ছাড়বে আপার প্রাইমারি
Upper primary তে
my lord kindly
I understand.
settle that issue. And what we are
Now government who is appearing for this
I
state?
am for the state now.
No, state has to take a call whether you are giving the pay protection to them. If they-
Affidavit has to be filed on behalf of the
Yes.
state. My lord, what
how
troubling
can
us?
it be resolved? It is not acceptable that a primary as
Higher
a primary teacher he is getting less amount than the teacher of upper primary. Why then you say will go for upper
My lord,
primary?
the challenge made by the petitioners, my lord, I cannot stand in the way. What is troubling, my lord, suppose X school is running with a 2 teachers. One is left with a rider to the temporary release.
No,
My
no,
lord, we
if
cannot
this
substitute.
issue, Mr. Das, if this is issued, addressed in this way, they will get the pay protection. Whatever step government takes, then everything is clear. They will release from there. School will be vacant. You fill up. Everything will be.
But I have understood. But I have understood.
But for time being release is required, which is why my lord I proposed order.
You go through this order.
My lord, that is annexed. Page 15 and
Disposed of.
no. My lord, affidavit
Oh,
of
আচ্ছা affidavit. যে কবে দিয়েছে এটা? মানে এগুলো 28 complete. Course like this.
Last one task.
And led by Mr. Jishnu Shah.
But other matter maybe it is still recess.
Wait, you don't know. It is up to them how far they will go.
But we can start the argument, the second appeal, but subject to that your lordship on the last occasion, your lordship may remember about formulation of the additional substantial questions of law. Yes, your lordship will kindly come to the page where we have proposed 3 additional substantial questions of law. একটা পাতা আছে দেখো না দুটো
This one.
Yes, that contains 3, After your lordship was of opinion that we should be reducing our proposed substantial law, additional ones.
Four substantial questions.
No, thereafter we have reduced to 3. Since your lordship were of opinion that 3 and 4, almost pertains to the same.
এটা বার করে দাও নাহলে কনফিউজড হবো এটা বার করে দাও নাহলে কনফিউজড
If your lordship comes to the order of admission at 14th January 2020.
কেটে দিন তো হ্যাঁ ওটা তো লাগবে না এটাই তো
First matter that my junior is here.
Carry on.
But your lordship will kindly come to page 36 of the paper.
Yes, I am.
Yes, lordship. The first substantial question on record is that in view of the categorical admission of the plaintiff respondent that there was a verbal agreement between the parties for construction of a building at the said plot of land, and that the ground floor would be given to the plaintiff respondent and the first floor shall be kept for the appellant, whether both the courts below was justified in decreeing the suit in its entirety. This was one. So when you come back to the merits, will show before your lordship wherefrom it has arrived at. Whether a suit for recovery of possession can be proceeded with pending a suit for specific performance of an agreement in view of the fact that the impact of the decree passed in a suit for specific performance will have a bearing on the suit for recovery of possession. There is a pending specific performance suit which is still pending as of now. The impact of the pendency of that suit upon the recovery of possession.
Is there any change of law? Supposing a suit by tenant for specific performance and suit for eviction.
But that is the merger of the status. The Supreme Court says that when the status of a tenant is merged that of a owner, but in that case, the suit of specific performance, that is no longer maintainable because there is a merger of the status. But so far here,
I'm not on that point. In a case of eviction, in a case of suit for specific performance, the subject to what you people say that the view was that eviction suit cannot be stayed for the pendency of the specific performance. If you succeed, you will go back. This was so far I recollect. Is there any change of
to my knowledge, no.
Then then
but Joseph, I don't. But this question has been in your lordship's mind for quite some time. But to be very frank, Lord, it's
somewhere I have seen, but I was shocked really because this was a long stand.
Go out and then come back.
At best, you can get an order of injunction in the not to third party interest to be created. It lagbe na, বুঝলেন? এইটা দিয়ে
টাইম লাগে কেন
এইটা না।
তাহলে তুই আছিস কি করতে পার
Then the third one,
Number whether the appeal being a continuation of suit or a lease is essentially a question to be decided for the purpose of applying the test laid down in the Privy Council in the case of Arif versus Jodunath Mojumdar reported in such and such and Pir Baksh versus Muhammad Tahar reported in such and such. Upon admission of the appeal, upon formulation of the substantial blood, we will rely upon blood these two judgments. Blood, let us blood blood come to the additional substantial question of law blood. That is,
let me at least take some idea about this.
but
scope
I
of
will
this.
hand up blood the copies of blood this.
No, you have got the appeal admitted that the court is to follow the decided purpose applying test laid down in that.
Lordship.
What is a test laid down?
But
At
that
least
is
the
blood.
prima facie.
That is blood. I was. আরে কপিগুলো দে না জাজমেন্টের আগের দিনকে তো নিয়ে ঘুরে বেড়াচ্ছি একটা ছেলেও আনবে না কপিগুলো blood till they find out blood may I take your lordship to the additional question of law. Now, blood, the additional substantial questions of law, blood, that we have proposed, blood, that for that there exists a substantial question of law as to whether the learned judges in both the courts below were correct in passing a decree for recovery of possession of the suit scheduled property, overlooking the plaintiff's admission that only possession of the land and not of building had been handed over to the appellant defendant, as a consequence whereof there could be no question of grant of license of the suit scheduled building premises to the appellant defendant, and in any event such license and even the purported license of the land would be governed by the common law principles in line with the provisions of Indian Easement Act 1882. Particularly as the defendant appellant had admittedly made a construction of permanent nature on the land against consideration paid to the plaintiff. Now, this is in the line of, because before the appeal court, there are 2 points taken. One of the point was that there was a permanent license granted by virtue of the permission to raise permanent construction.
Therefore, if we
and
make the precise this question of law you are indicating,
Lordship,
that this since construction, the building was erected on the land of the plaintiff on his permission, and the nature of building is a permanent structure since has been, that your possession over the building is protected by virtue of the Indian Easement Act.
One, and secondly, it was also a point
It's a
taken
nature of permanent license.
Yes.
Irrevocable license.
Irrevocable. And other point taken before the court below was, the appellate court below was blood 53A of the Transfer of Property Act. It was by virtue of the part performance blood, the property was handed over because there was admittedly there was an agreement. And pursuant to the agreement, blood, the land was handed over to my client, to which blood he has built upon 2-storied building.
So your agreement is to the extent of first floor only.
Agreement was blood in respect of
for agreement for sale. You are restricting it up to the first floor.
No, blood. I was opposing their application for recovery of possession blood on the grant blood. They were contending there was a license.
You are objecting to their prayer. You are protecting your possession in respect of the entire property.
Entire property.
Please read the question number 1. May I make it clear? If I take the admission of your possession in respect of first floor, admitted position, court has overlooked it. Then your filing of this suit for specific performance admission of their title, and your further admission of title is the permission to erect a permanent exchange structure, thereby converting your status as irrevocable licensee. Please reconcile the whole situation.
I'll tell you, Lordship. Blood, to my understanding,
contradiction on in
blood. there are two concepts operating here, blood, in my humble understanding. Blood, one is blood acquisition of title. Other is blood that I am saying that you cannot seek recovery of possession because of a permanency attached in the nature of the license granted. So one is rather blood acquisition of title, and other is that you cannot seek recovery of possession.
Mr. Mukherjee, I am considering your question number one.
My lord.
You have reduced it in so many sentences. It can be reduced subject to what?
But that can be made
line,
more concise.
That your possession is protected. You being a non-evictable licensee under the Easement Act, your possession is protected. That is, you want to say possibly additional question of law.
Lordship.
But this additional question of law, if it contradicts with already the question of law framed,
Lordship.
how can it be framed?
And the pleading.
A pleading that will show.
So, Lord, I'll show before your lordship how Lord, the questions have been dealt with by the appeal court below. Now, Lord,
the question was agitated in the court below.
The first appeal court, Lord, the question about Lord, the permanent license and Lord 53A were agitated.
Was there?
Yes.
Achha.
Subject
Therefore,
to correction by my lord.
According.
Argued. Yes. Yes, it was argued.
Why I'm saying so, if my learned significant doesn't take offense, but I'll just take your lordship to one paragraph of the written statement. Lord, where paragraph 10,
But let him come up, Lord, after I finish.
No,
Lord,
no,
whether there is
Mr. Chatterjee,
because all that I say is that
Mr.
Lord, I find from the
Mr. I want
first
to
appeal court
reconcile
dealt with the
the
matter.
situation.
Exactly why I wanted your lordship to see, my lord, what his pleadings are. He says he's not a licensee. So today, my lord, before the second appellate court, he can't, my lord, want your lordship to frame a question on license. He is saying I'm not a license. So that is in contradiction to, my lord, his plea.
Therefore, the pleadings is in contradiction. What he proposing to do, according to you, very well.
Lord, as it fell from your lordship about the first additional substantial question of law, Lord, the couching of the language, Lord, we can make it more precise. But Lord, so far as Lord, the original Lord, the substantial question of law, Lord, that doesn't specifically Lord, talk about Lord, the irrevocable license being granted.
No, that is not.
So Lord, this is the intent and purpose.
What is appearing that both the courts below have overlooked that there is an admission that the ground floor between the parties for construction of building on said ground land, and that the ground floor would be given to the plaintiff.
Yes.
This is overlooked. Now, this was on this. You please connect it on this. On this assurance, if you have constructed a house, you are given possession of the ground floor. Reality, ground floor. You want to protect your possession over the ground floor, not the entire property. But now you are proposing that this ground floor possession is protected as you have acquired irrevocable license. Please connect these two.
Because of the fact, Lord, that we have already paid money, Lord, to the plaintiff. That is, Lord, all on record. It is the case of the plaintiff, Lord, that they are trying to say that they engaged my client for raising and construction. They could not show, my lord, that for the consideration of raising a construction, that they have paid money to my client. When your lordship, Lord, I take your lordship to the evidences on record, your lordship will find that there are certain money receipts. The money flowing from my client, Lord, to the plaintiff. So that is quite an indication of the fact that although, Lord, the agreement spoke of the fact that there will be a retention of the first floor by my client, but in fact, Lord, the ground floor and the entire building was, Lord, raised, including the basement, what it has, at the cost of my client. So, Lord, in that perspective, my lord, it is my case that, my lord, I have an inevitable, my lord, right in respect of the entirety of the property. Because of, Lord, the money has been spent and it was an arrangement between the parties. Because your lordship will also find in the evidence, Lord, that agreement that was entered upon, this being a Salt Lake property, was subject to, Lord, vetting by the appropriate government, the competent authority. Now, my lord, so far as the first additional substantial question of law is concerned,
Irrevocable
but this
license.
is, my lord, we can make it concise so as to, my lord, put
Irrevocable
irrevocable
license. It is irrevocable license.
irrevocable
Then
license.
the second one.
Lordship. For that, there exists a substantial question of law as to whether the learned judges in both the courts below were correct in passing a decree for recovery of possession of the suit scheduled property, overlooking the fact that the appellant defendant cannot be a trespasser in view of the admitted agreement dated such and such that was entered into between the parties and the admission made by the parties in course of deposition. So there was a clear-cut deposition, my lord, that I was not a trespasser. I was allowed and handed over, my lord, the land for building up.
No. Supposing you have come under an agreement to the property.
Lordship.
The nature of agreement is agreement for specific, rather sale, agreement for sale.
Agreement for sale. Contingent upon the permission.
Was there any time limit prescribed there?
That I have to go through, Lord. I have not. আছে তোর কাছে এটা দেখো আছে এক্সিবিটে তো আছে
Suit is for execution of trespasser.
But on the ground of recovery of possession, on the ground of blood revocation of license. It is a case that I am a gratuitous licensee.
Then whether you are, your such license is protected by the provisions of this. You have become irrevocable license.
Lordship.
Your license has become irrevocable or not. And that may be a question of law, subject to what he says. Of course, this is prima facie. But there ultimately,
If your lordship formulates a question, my learned friend at the time of arguing can always say, Lord, that it is not a substantial question.
Obviously.
So, Lord, it is always after formulation that comes.
But this second one, what you are saying, that you are not a trespasser, that is
Lord, that is not taking a cue from
because
53A. That is a
separate question of law need not be framed for this. But I'm only asking you to consider whether formulation of the first one is supposed
we can make it a bit more concise.
Will affect any of the grounds already taken, already formulated.
But in my reading, Lord, I don't find, Lord, there is.
Mr. Mukherjee, don't be sorry. Don't be sorry. Don't be sorry.
A time limit ছিল পড়েছিস ঠিক করে আন্ডারলাইন করা মানে পড়ানো আন্ডারলাইন করা মানে পড়ানো
Suit is based on the agreement dated 3rd July 85.
Lordship.
That is already covered. This third question of law.
Yes, that is covered because that is similar to
there is no use in multiplying the question of
very well. Very well.
Easement একটা দাও একটু annotated হলে ভালো হয়. Mr. Mukherjee, Mr. Chatterjee, have you got an annotated book of Easement Act? Easement Act. Annotated.
Lord, we both have it, Lord, at
Both have it.
home. Nowadays, Lord, we have a bad habit of not using
Not a bad habit.
soft copy.
ওইখানে একটা ইয়ে ছিল না সিভিল প্রসিডিউর কোড
হ্যাঁ there is some, Lord, annotation. It's a little bit of it.
And I'm sure that he will be taking up the point of applicability of.
But he will
Indian
certainly,
sa-
Lord, he has
Indian-
already taken Mr. Chatterjee about Lord, the principles
obvious,
application and
obviously.
Lord, whether Eastment Act will
Application
apply or not.
in,
Lord, those are there.
in Bengal.
97 Supreme Court 1041.
Yes, he has already taken that point.
But I've come on, I'm not even going to that step. Saying you cannot argue that anymore.
But shutting out an argument, Lord, may not be a question before the Supreme Court at that point of time.
Concentrate on a suggested question number 1.
Lord, sir.
Mulla Ana library. Concentrate on 1.
Lord.
And
Lord, 1 and 3, Lord, we are omitting 2.
3, not very appealing. It may offend your first question and third question may. For the timing, you may leave aside. But give me এটা দাও না মোটা মোটা করেছে না ওরা কত রিটেন স্টেটমেন্ট পাবো যেখানে
But may I take your Lordship, Lord, to the judgment that was passed? Because, Lord, before your Lordship goes to, Lord, the written statement, because the courts have gone through, Lord, a point that we had taken.
Paragraph?
The last line before paragraph 11.
Paragraph 10.
The time of argument to show it. After all, I'm going into the merit. I'm going. Take the stage of order 41. Take the stage of order.
Yes.
Whatever this there, you may argue also. I think you will, of course, that this is a stand which destroys the already formulated questions. You may take it, but as you have described the defendant as a licensee and defendant intends to take the ground of section 60B. B.
That needs to be first there in the pleading.
Suppose you are not there, supposing order 41. You are not there. That court had not considered the case of a irrevocable license.
No, consider.
Wait. Irrevocable license, because admittedly land belongs to X and I defendant has put up the construction. Therefore, whether my possession in the suit building is of a irrevocable license which can be revoked by the licensor, this may come up a question of law. Of course, it is his risk. He is taking it because simultaneously a case of title he has.
He's run a case of title.
He's run a case of title. So whether it can be at all sustained or not, there is a.
Now, my question before your Lordship is at this stage, I'm not on merits at all.
No, suppose now obviously at the time of admission,
I don't have a right of audience.
I have to see the judgment itself.
Absolutely.
How it has been dealt with, what facts has been recorded over there.
Absolutely. If your Lordship finds an infirmity there, then Milord, your Lordship will, Milord.
No, if it is in the judgment, it is
very
found
well. Taking the cue from my learned friend, kindly come to the appeal court, sir.
Absolutely.
Let us not see what not the appeal court has dealt with.
Because Milord, your Lordship would remember, Milord, that this is not a plea which is taken in the written statement.
No, I'm not thinking. Supposing I'm not taking it. These two judgments are before me.
My Lord. Then they take the plea at the appellate stage.
Yes, that is where I am.
I'm saying, I know, they take this plea at the appellate stage at the time of hearing, arguments.
How this has been dealt.
How was the
Yes.
judge? And if
Now, my lord,
given
these questions were raised, my lord, qua the evidences on record. It is not that, my lord, that
Come to the appeal.
Yes. Now, my lord, your lordship will kindly come to page 20 of, my lord, the small paper book, my lord, which contains, my lord, the judgment.
Say it is a paper book. Other rest are not. Yes.
Lord, your lordship will find, Lord, that the judgment, Lord, starts at page 20 by quoting out, Lord, the grounds. Lord, the grounds have been quoted.
We can skip over.
Lord, your lordship wanted to see that Privy Council judgment.
Yes, we have it.
Your lordship has switches on the airdrop, I'll send it to you.
সব বলে ওকে দাও এটা ধর।
কি বললো?
Your lordship never knows what more will be dropped there.
I don't know.
If your lordship wants it, Lord, I can always
Lord, we have a copy. Lord, we can assist your lordship by providing a hard copy. Lord, we have.
But
Yes, I am wanting that judgment.
Judgment is galore, Lord. Apart from that, if
That
anything,
judgment that I missed to note.
No, I don't.
I was somewhere. It was because it was very shocking.
They are all changing the law. That is up to them. Even Akamma Milord says 34 has gone. Proviso has gone.
হ্যাঁ দাও কোথায় এয়ার ড্রপ ওপেন করে এটা দিয়ে
দাও
এয়ারড্রপটা ওপেন করো
দাও দাও
ওই তো না ওটা টিপে থাকতে হবে দাদা হ্যাঁ
ওখানে এয়ারড্রপ এভরিওয়ান 10 মিনিটস 10 মিনিট বাদে এমনি বন্ধ হয়ে এক্ষুনি একটা অ্যাকসেপ্ট আসবে আচ্ছা তুমি আমার কাছে রাখো
এটা কাছাকাছি রাখো নাহলে হবে না saying. Mr. Mukherjee cited it, not senior Mr. Mukherjee. He was
No, I think, Lord, if your lordship comes to page 1245.
Which portion, which line?
Yes, Lord, I'll just, Lord, try to, Lord.
Very well, very well. We have not. Then in appeal court, what is your pleadings to that?
Lord, your lordship will find that, Lord, portion, any relief granted or protection afforded to the person in possession will be founded on the contract. But the fact of part performance renders unnecessary the protection provided by the statute in its requirement of a memorandum of terms signed by the parties to be charged. It is stated in Madison versus such and such equitable doctrine of part performance. Lord, I think for this reason, my lord, it was cited before the court, Lord, considering, Lord, the part performance of the contract. Arif was cited for that reason, Lord, because, Lord, the language that has been couched.
Arif is not only a pointer for the protection of your position over this. I think so. Very well.
Lord,
Now you take me to the appeal court. Take me to
Lord,
the appeal court.
Now, Lord, the ground number 2 at page 20, the learned trial court failed to apply her mind to consider the true intention of the parties prevalent. At the time when the exhibit G being a bilateral agreement.
Page 20.
Dated, page 20.
Appeal court starts here. Grounds taken.
Grounds taken. Of the grounds taken, ground number 2 is about, you know, the exhibit G, the agreement dated 3rd of July 1985.
Ground number 8. Page 21.
Ground number 8. Yes. That is 60B. Then, Lord, the ground number 7 is 53A.
No, we are on the additional question number 1.
Yes, then, Lord, it is ground number 8.
8 was taken.
It was taken.
How the appeal court has dealt with it?
Yes, now your lordship will come, Lord. Page 25, on going through the entire evidence, Lord, the appeal court's, Lord, application of mind starts.
Page 26.
Page 25, on going through the entire evidence on record.
5 at bottom. Last line.
Is this correct? When he has not taken it in the court below, cannot take it in the first appellate court?
Now, Lord, your lordship will then kindly come.
I'm reading it. Page 26, last line.
Lordship. Lord, I've gone through that. There's Lord.
And page 26B.
But just a moment, Lord. Now, Lord, your lordship will kindly come to page 27. Lord,
27.
The learned judge says, my lord, on the question of 60B.
Yes, this is 26.
Now, regarding application of section 62 of the Indian Instrument Act, the fact remains that when defendant has not taken the plea before the lower court, he cannot now claim his license as irrevocable.
Whether to the first appellate court.
Both facts and law.
Yes.
Both facts and law.
Whether justified in holding that plea cannot take the plea. This could be a question of law if you want to propose.
Very well. Very well. Lord, I'll have it recasted in that way.
Recasted
I'll have it recasted that way.
Since the plea was taken in the first appellate court, whether it was justified. Couch it in that way.
Lordship.
So this will be, I think, that the last question of law Mr. Chatterjee has to deal with.
Lordship.
So, Mr. Mukherjee, learned senior advocate for the appellant, proposes for formulation of few additional substantial questions of law, out of which the following one appears to be involved in the present second appeal, inasmuch as in the first appellate court, the appellant had taken this ground from the whether the substantial question of law is formulated it is already there. If not in terms you want to say, your whole protection is I am a holder of an agreement for sale pending applicable suit for I came into possession on the strength of that document. So pending disposal of the specific performance suit for eviction cannot proceed. I cannot be evicted. That is your sentence. Come to the main matter now. Let us start with the main matter.
But may I just first place, my lord, the trial court? হ্যাঁ রে আচ্ছা সবাই হাসছে শুনে এটা ঠিক it is at page 5. This is a suit for declaration rupees 100 and for eviction and khas possession on revocation of license valued at ₹100, for mandatory and prohibitory injunction ₹100, and for a tentative mean profit damages ₹1000. Plaintiff's case in brief is that the plaintiff got the property from Metropolitan Development Department Salt Lake branch on the basis of allotment letter issued by the government in favor of the plaintiff. Subsequently, Government of West Bengal executed a deed of lease in the name of the plaintiff on 12/9/84.
How the parties are related?
Lord, according to them, Lord, my client is Lord Mamar কি হয়? মামার মামা শ্বশুর।
আচ্ছা।
কে কার মামা শ্বশুর?
আমার মামার শ্বশুর।
ও আচ্ছা। Lord, the plaintiff is Lord Mama Shoshurmosai of Lord the defendant.
আচ্ছা, আচ্ছা, আচ্ছা। This is ultimately fight between the Shoshur Jamai.
Not that, not that. The purpose was Lord that the property was sought to be conveyed. Now Lord something different has cropped up. On the basis of the allotment letter issued by the government in favor of the plaintiff, subsequent Government of West Bengal executed a deed of lease in the name of the plaintiff on 12/9/84. But the proximity of the dates will be important because to find out the purpose. And the plaintiff was in possession of the property. The plaintiff constructed the residential house in the property and executed a registered general power of attorney dated 3/7/85 in favor of the defendant on certain clauses. From time to time, the plaintiff paid money to the defendant for the construction, and after part construction of the house, the defendant started to live there for completion of the remaining work. The plaintiff contacted the defendant for delivery of possession and accounts of construction, but the defendant was avoiding to render accounts and kept the premises under him illegally. The relation between the plaintiff and the defendant is that the defendant is the maternal uncle's brother. Naturally, he is the trustworthy person of the plaintiff, and for the sake of that, the general power of attorney was executed in favor of the defendant. Since beginning of the year 2005, the plaintiff time and again asked the defendant verbally to vacate the suit property mentioned in Schedule A. But the defendant did not vacate the same in spite of assurances and undertakings given by the defendant to vacate the same by 31st of December 2005. The defendant did not vacate the premises on 31/12/2005, and accordingly, the plaintiff revoked the verbal license granted in his favor, and on and from 1/1/2006, the defendant became trespasser in the suit property. The plaintiff revoked the general power of attorney, which was granted in favor of the defendant by registered instrument dated 10/12/2009, which was duly intimated to him by a letter dated 10/12/2009. Publication was made to that effect. At present, the defendant is trying to encumber the property and to let it out to third party without the permission of the plaintiff. Hence, an order of permanent injunction is necessary against the defendant not to do any act which is detrimental to the interest of the plaintiff. The plaintiff is entitled to get damages for wrongful use and occupation at the rate of 1,000 rupees per diem till 1/6/2006 till recovery of possession. The cause of action for the suit arose on the dates when the plaintiff from time to time demanded from the defendant to vacate the possession of the suit property on 2005 and subsequently on every day, and lastly on 1/1/2006 and on 15/3/2006 when the defendant flatly refused to vacate the premises. The property is situated plot number such and such, sector 2, PS Bidhan Nagar. Plaintiff prays for a decree that the plaintiff is the real owner of the property in the suit property and is entitled to recover khas possession of the suit property, mean profit, and mandatory injunction, directing the defendant to return all the relevant original deeds and documents relating to the suit property. But when I take your lordship to the plaintiff, I'll show Lord their prayer is for a declaration of Lord their title.
Yes, Mr. Mukherjee. Therefore, all the deeds referred in this narration of judgment, that is, the deed of lease is exhibited document.
Yes, Lord, your lordship will find that Lord at page.
No, let me understand one thing.
But the list of exhibits are here in the order.
The
Judgment.
power of attorney also exhibited.
Lordship.
Is there any evidence,
Lordship,
to this case of the plaintiff on record that the defendant, when came into possession of the suit property, it was partly constructed?
In my respectful submission, no. That's the reason I said that if your lordship will
When-
kindly see the proximity of the dates.
And when the building actually was constructed,
But it-
completion of the building, is there any evidence on record?
completionটা হয়েছে 2009 না?
স্যাংশন প্ল্যান তিনখানা ছিল
Completionটা কবে হয়েছে? একটা ডেট
1990
1990.
Is there on record? We can ascertain from
Lord,
the record.
this is Lord,
We can ascertain from record. We will inspect to the record later on.
lordship.
So, the half construction was not done in the record.
But that was a point that I took on the first day. Lord, that what was Lord handed over to my client was a bare piece of land. There was an accretion on the piece of land. On the Lord, the built up property, he is now seeking recovery of possession.
That I understand. I
So,
want to know
Lord-
about the evidence, whether there was anything. The plain case is that this was half complete house. I inducted my relation over there and asking him to complete it. There is nothing, at least in the whatever
When
the
I take
learned
your
trial
lordship Lord,
judge-
to the agreement for sale, your lordship will find it from there what it means to say and the power of attorney.
I'm just letting you that so that your search to the records will be easier.
Lordship.
And when you, that is the plaintiff's case recorded by the trial judge,
Lordship.
that your client came in a half complete house where he was allowed to stay, and then he may be asked to complete the construction, staying over there. The recording of the plaintiff case does not say who will finance that construction. That we have to see from the record. And when the construction was completed, and if why relevant? Because thereafter, when he was asked to vacate,
Lordship.
suppose
And when Lord, the power of attorney was cancelled after Lord.
Yes.
That is a short list, Lord of
gather
Lords.
the intention of the parties, what kind of status the plaintiff wanted to confer upon the defendant
Lordship.
in respect of the suit property. Then this is up to the plain case recorded by the
And Lord, thereafter the defense case starts,
Yes.
Lord. By filing the written statement, the defendant stated that the ownership claimed in respect to the suit property by the plaintiff till date is not true and therefore denied the plaintiff has lost all his right, title and interest consequent upon of interest and possession of the defendant. It is also untrue that the plaintiff is or ailing person for which he appointed the defendant as constituted attorney of the plaintiff to look after the property are all baseless and malafide allegations. The plaintiff has suppressed the fact from the learned court and is therefore disentitled to any assistance of equitable court. The statements made in para 4 and 5 are all merciless lines and the causing plaintiff is in the habit of defrauding many persons. Fact remains that the plaintiff is a distant relative of the defendant. He got an allotment of government of West Bengal in respect of a vacant plot of land, but he got no requisite fund to buy the same. He approached the defendant to obtain the land by payment of consideration on the particular point of time. He also promised that after the allotment is made and necessary conveyance is executed by the government of West Bengal, he will arrange for the permission of the lessor to make such transfer in favor of the defendant. And accordingly, on 3/7/85, an agreement for sale was entered into between the plaintiff and the defendant. The defendant paid rupees 2,20,000 as consideration on obtaining proper receipt from the plaintiff, and the plaintiff received further 20,000 on different occasions, but no receipts were granted. The plaintiff handed over at the time of agreement all the original deeds and documents. His brother, Jayanto Chakraborty, is the witness of the entire deal. He had not spent a single farthing for the construction of the house, which has been done by the defendant, and several lakhs of rupees were spent. In 2004, defendant received a letter from the plaintiff that he wished to donate the building, and the instant suit filed in the year 2006 making false statement. By filing additional written statement, the incorporated amendment is absolutely false, speculative and malafide. It is absolutely false to suggest that the plaintiff constructed the residential house in the leasehold, or on the contrary, the plaintiff for consideration executed several documents wherefrom it will be evident that on getting to full consideration, the plaintiff has transferred his possession and title, but owing to the embargo incorporated in the Urban Land Act, no transfer could be effected without the permission of the competent authority. And it is also in the document that as soon as the embargo will be lifted, the plaintiff will be bound to execute and register proper deed of conveyance in favor of the defendant. As a matter of fact, since from the date of execution of the agreement, the plaintiff has been divested with all right, title, and interest in respect of the suit property. Therefore, question of vacating the suit property is absolutely utopian claim, not tenable in law. The defendant further state that since the government of West Bengal has lifted the embargo with certain terms and conditions, the defendant has immediately filed the suit for specific performance of contract before the second civil judge junior division at Barashat being
Post eviction suit. Post eviction
suit, because this is not after the lifting of the embargo. Because
2013 embargo was lifted.
Yes. The moment it was lifted, we had filed this.
2005.
12 12. There's a 12 notification we have relied upon and it appears from the record that inadvertently no issues have been framed till date, and for adjudication of the matter in dispute, the following issues are framed at the time of
This is defendant's case.
Lordship. Now, Lord, the issues, Lord, of Lord, there are a few issues, not only 5, of which 3 is important. Whether the defendant is a licensee under the plaintiff. Therefore, Lord, the issues are, Lord, also very scanty here, as we find. And Lord, your Lordship will find at page Lord 10, the evidences, those have been marked as exhibit, and Lord, these are all before your Lordship in the additional, Lord, the volumes that we have bound and
Is there any evidence on record showing that the plaintiff had contributed in constructing the house?
No. Nothing. Nothing. But I'll take your Lordship, Lord, to his evidence. And Lord, the documents, Lord, what he had filed. The documents is not the original copy of the lease, original certified copy of lease, original. I'm sorry.
Give me
Lordship.
When he will be available in India, give me a date.
I have to talk with Mr. Shah.
No, not he.
Yes, Lord. We call India the third visit.
আমি তো ইন্ডিয়াতেই থাকি
মাঝে মাঝে সেটা মাঝে
সময় ইন্ডিয়াতেই আছি
Next Friday, my lord, if it commends to your lordship.
Is fixed.
He is called.
Oh, Mr. Haradhan Banerjee is there.
Oh, then Lord, Friday week, Lord. Oh, ha, 14 তারিখ. Then Thursday it may be 13th.
Not be available, na? Mr.
Holy week, Lord.
আমি আছি
He has grown up.
He has grown up.
না না আমি পাচ্ছি আমি একদম grown up
এই বিষ্ণুধর কি অবস্থা
Thirteenth, Thursday, 2 p.m.
Lordship. ক্যালেন্ডার কি করে তাড়াতাড়ি ছুটি
On 10 February.
On 10th February, it had been made CAV minus.
10th of
10th of
February.
Hearing was concluded.
I have some.
Before anything else,
The last order.
we see because
judgment reserved.
Judgment is up. Lord, may I?
Let us meet after Holi.
No, I just pardon me for a few seconds. This is relating to, as your lordship says, with supernumerary posts. Lord, may I make first submission in this way? That there is an application for addition of parties. That has nothing to do with the decision of the Supreme Court on supernumerary posts. Kindly allow that application.
देखिए application तो देखिए.
Can 2 of 2023.
My application is Can 4 of 2023. Can 5 of.
Where is the petitioner?
Yes, the petitioner is here.
The petitioner, Mr. Bhattacharya, is on its way.
Ask him to come. The application they are paying, it should be.
I have already.
The appointment, the applicants.
I appear for the applicants. Not
Your clients have received the recommendation for
Yes,
appointment.
yes.
Yes,
The applicants.
recommendation has already been given. But
They are the applicants.
they are the applicant.
They are the applicants.
They are the applicant.
देखिए application.
Can 5, Can 6. Can 5 or Can 2 or Can 3.
How many applications are pending?
Mr. Shenkumar is appearing for Can 2
And you have one.
Can 5.
They want to be added in your writ petition.
Yes.
What is your response?
But there possibly cannot be any objection because we are necessary parties. Supposing they succeed, then
You will be affected.
we are affected.
Possibly, I also directed issuance of notice to yours. Possibly, I don't remember. That those will be affected by this order if this is held. That this creation of the supernumerary is not in accordance with law.
Can 2 and Can 5. In Can 2, there are 201 applicants.
In Can 5, there are 13 applicants. And apart from that, there is applicants.
বেশি কিছু কর
Who is in Can 2?
I'm for Can 2.
Sir, you have rightly prayed that if the addition is allowed, then the cost title of the writ petition is required to be amended. That prayer you have also made.
But there's a normal.
Is to facilitate it. Can you do one thing? Of the applicant need to be added with the Can number so that the department can, instead of writing in hand in every pages, can give it to the after addition as respondent. Will be adding as a respondent. If, after hearing what, of course, Mr. Bhattacharya, what he intends to say.
Possibly, Mr. Bhattacharya is always a very fair.
No, this is
will not object.
in my opinion also, because I'll be giving you hearing in whatever may, without adding or adding or without adding. Because if the court decides that the state has no authority to create such, if not by the
Even if I am added,
Supreme Court
that
makes something
yes,
by the time.
even if I am added, they will not be affected because if they satisfy your lordship, the supernumerary report was not properly.
Will not be affected, but the court will be benefited to hear you formally.
Not, by
Now
privilege we have to appear before lordship.
can you do that?
Yes, lordship. Yes,
All
we can
applicants-
give Milord also Milord if what formats or Milord in the pen drive so that it can be
No, pen drive will not do. In the read
Very well,
petition, it will be
very
added.
well, very
Where is Mr. Bhattacharya?
Mr. Ahmed আছে তো?
So this provide me who you are one of the applicant 2, can number
And
2.
number 2.
And this is can 5. Any other application?
They are not before. They are not here.
আর কটা অ্যাপ্লিকেশন আছে আর বলুন? 1 to 7. You are assisting Mr. Bhattacharya. If they are added, have you got any difficulty?
Here the parties.
Because I understand this impression has been given to me. You check up. I will give you 2 days time. You check up that whether they are the recommended candidates or not. Because names will be inserted here. Thereafter, the claim will that my name was there. Consciously, it will be given with the signature of the advocate on record.
We have annexed the
We have annexed the recommendations.
No, not that. Sir,
And in the application, we have annexed everything.
there are different numerous types of allegations. That in one of the allegations, what I found, that the court had directed only those who appeared in the earlier selection test. They are allowed to participate in the subsequent selection test. Now,
in this matter?
No. In some other selection test.
2016 SLSP.
So it is now the allegation is that no, the person who have been given appointment, they never appeared in the first selection test. So what I'm anticipating, if the names are not certified that they have been given a recommendation and they are the applicants of, supposing in between Mr. X name is given, and after that appointments given, then he will come that I was there. But,
certificate.
This is.
I want.
They have served. Probably they have served. I have to check whether all of them. For certainly, I can say Mr. Bhattacharya and the senior Mr. Sengupta have served. That I know, my lord. Whether everybody has served.
No, everybody is not appearing. We are pressing only for 2 applications.
This is not the piecemeal way. If the 7 applications
I don't know what are those about. I do not know what are those about. For addition or something else, I do not know.
And they are not appearing before your lordship also.
Really, they have no urgency about it.
Since they are paying for addition at prima facie, what are the applications for addition? If there are other types of applications, you inspect the record and apprise this court. And if the yes,
1 or 2 days time.
yes, and if it is found that these applicants are recommended candidates, they will come in a piece of paper with this that they are the applicants. Advocate on record shall certify, and these will form part of the writ petition.
Yes.
And your clients will be added as respondent. So first, these exercises can be carried out pending the decision of the Supreme Court first. Mr. Dasgupta, have you got any objection for their addition? Addition only.
If they are added, each of these 200 if they have been recommended as alleged, my lord. If they have been recommended, my lord. Also on the last of it felt from your lordship that in any event, whether it is if they are added or not, they will be hard, your lordship.
Yes, then.
If your lordship.
But Mr. Sengupta, it is somehow it is necessary that they should be added. After all, they are held to be necessary parts. How you will be?
Have at all any right have accrued or not?
No, to that we have a lot of submission. No submission. One clarification.
No, not the policy. Whether the state is in these circumstances, in the backdrop of the present, whatever has lead to creation of the supernumerary reports, whether the state is justified in creating such supernumerary.
Has to recommended kind has nothing to do.
No, that is not the subject matter of the writ petition only.
Wait.
Joseph,
No, I'm hearing to that extent only. This is the only issue before me.
only Meenakshi
Now,
was before you.
To get the assistance, obviously they are defending the creation. So it will be beneficial for the court to get the assistance of Mr. Sengupta. But formal addition, Mr. Bhattacharya, till this judgment is delivered, nothing can be. I will not proceed. But in the meantime, what Mr. Sengupta is suggesting, the recommended candidates in the supernumerary reports, they have their application for addition. If this application is allowed, they are formally been made party. Is there any difficulty?
Because they cannot be allowed because there is no right which has yet been accrued in their favor. Lordship knows in the...
Sir, 1 minute. Post has been created, recommendation has been
Yes,
made.
but till appointment is made, Lordship is well aware of the principle.
Yes. No right to the post is created. But ultimately, if the decision goes in your favor, who is the affected person?
None.
The one who has recommended.
No.
We have got the recommendation letter. We have
Not at
gone to
all.
school.
Without even after preparation of a panel will not, no right accrues unless he is appointed. The settled proposition of law. Today, they are not going to be affected in any way.
No, today, if you are successful in demonstrating that the state has no authority to create, in this supernumerary report can create, but in the backdrop of the case where it has been done here, cannot be done.
Because cannot create. Supernumerary reports cannot be created by the state when there is specific recruitment rules. That's a more fundamental question on which we are before the Honorable Court.
But
now, none of
that is at the instance of people.
Let me say. Now, if these people are allowed to be added, the ultimate aim is that then there will be 500 SLPs before the Honorable Supreme Court.
So what?
That's why you don't have the right.
Where is the bar?
No, Mr. Bhattacharya, supposing I do not add them formally. If they are affected,
Allowed to intervene, I don't mind.
No.
Allowed to be intervened, argue, it's no problem.
Now, if it is not even added, then also they don't have, then they will not have a right to get and take an appeal against this order.
They have a right to prefer appeal on a leave application. If the Honorable Supreme Court finds that you are an aggrieved party on party. Now, these proceedings will not, in my deepest of respect to the Honorable Court and my learned friends, should not be extended to such a situation. Because this is pure question of law and the jurisdiction authority, apart from the question of the selling of jobs on money.
And at the instance of persons who do not even figure anywhere.
What is the other way around to look into? That you are no way barred from arguing whatever point is available to protect your client. Formal addition or no addition makes no difference.
Makes a difference. For this reason, if I am a party to the proceedings, I can always move out. Supposing, as your Lordship said, go to Supreme Court and have a clarification. If I go to Supreme Court will say you are simply an intervener there. At your behest, we cannot clarify.
For aggrieved party by the decision.
No, aggrieved party is first of all party.
If this is the situation when the writ petition, in whose petition you intend to add, they are objecting. Obviously, they have a right to file an affidavit to that.
We have served these long ago. Your Lordship's pleasure was, I'm instructed by my learned jury to say that your Lordships direction was call these 201 applicants, personally see them,
Yes, yes.
and then
Yes,
verify.
of course, without the person who will be ultimately affected. This is the fire between the state and the petitioner, and you are the casualty. So if that be the situation, you must be hurt. There is no doubt about it. I express my, but when the application for addition is objecting, the petitioner is objecting for many other reasons, they are entitled to use an affidavit.
The only thing is,
Let them use an
Lord,
affidavit, short affidavit even. Otherwise, without affording.
Lord, I affirm, I understand, Lord. One might say, without giving any chance of filing affidavit, court has allowed us.
Mr. Sengupta, you don't know what stand. Even the
I
government
fully
agencies
appreciate.
vacillating with their stands. So therefore, if you intend to be formally added, you take the pain of using affidavit to these applications. At least to the addition of are there any call the applications number wise? Number wise. Can one of
2025.
addition of party.
এরা সবাই can. এখানে can. আমরা ছেলেবেলা একটা গান শুনতাম can
This is Mr. Bari. এখন এই যখন কিছু করা যায়।
state.
কিছু বলে। আমার কাছে আছে। Can 2?
Yes, Lord.
Can 2? Can 3?
আমাকে delete of 2023 বলেছো না করবে জি তাই
What is the appropriate order? Oh, appointment letter. This is something else.
That's why I told you, Lord, I'm not aware of what is content of those applications.
can 4 of 2023 or can 4 I am pathetic.
What is this?
It's all recommendation.
What is this application about?
Application for addition of part.
Addition of এটা আলাদা পাওয়া। Five? Addition ওখানে রাখো। 6?
6 is also an apparently an addition, but they are not appearing today. I have a copy of 6.
6 is, are you leading the advocate?
No.
Addition of party.
6 is vacating.
6 is a vacating interim order.
আলাদা রাখো।
অ্যাপ্লিকেশন করতেই পারে আশ্চর্য
And 7 হাতে নেই।
একটা ক্লাসিক দিয়েছে অ্যাপ্লিকেশন ডিলিশন করবে এবার
Who is a junior in this matter, Mr. Bhattacharya?
মিস্টার সুদীপ্ত দাশগুপ্ত
Mr. Dasgupta use a affidavit to this.
Yes.
সবকটা
And 2 weeks after, Thursday.
Friday after 2 weeks is a holiday.
No, 13.
ওই পার্টিকুলার ডে
13 অন্য second 18 দেবে? meet on 20th, and by this time, if the Supreme Court declares,
Delivery judgment well and good. But if
yes,
my experience has any value, before May nothing will come because higher secondary examinations are there. Supreme Court will be told that, my lord, now this is interfered with. These persons will lose their job.
There is no scope.
Already told.
হয়ে গেছে 20 তারিখে পরীক্ষা শেষ
Already has been told.
So they have
in anticipation.
No, no.
In anticipation. The higher secondary examination.
What happened to the education system? The Honorable Chief Justice said, don't make this submission before this court. We have done something.
Education
No,
system.
the education system, my learned friend is saying, the writ petitioners do not even figure in the waiting list.
That's why
They do not even figure in the waiting list.
They
And they
will
are complaining a lot of things, not even being in, forget about anything else. They are nowhere, unsuccessful. They secured zero. They secured zero.
Unemployed.
So, we are at least
Unemployed youth.
we are also unemployed. We are also suffering. We are at the threshold of getting an employment that has been thwarted at their instance.
Must be thankful that without having any scope for getting anything, they are raising.
Paragraphs 1 to 20 centers around allegations which have already been decided by my lord's court.
Yes, CBI, I am keeping this order sheet. Entire bunch of order. কোনগুলো খবর দেখে
what is this?
But be sure. And be sure and conscious about the objection. of this.
কি বলছি শামীম এই শামীম কি বলছি আরেকটা কি বলবি
My lord, no direction for us as of now, my lord.
Wait,
there is another petition.
These are the three other.
Only Meenakshi Ghosh we are concerned with.
No, only one.
No. Only Meenakshi Ghosh, Mr. Bhattacharya's writ petition.
These are not related to the petition.
Meenakshi Ghosh?
রেকর্ড ইন্সপেক্ট করে দেখো, যদি একরকম হয় তাহলে একসাথে ফেলবে, নাহলে ফেলবে
কি হলো
দেখতে বললো যে এক হলে তাহলে সেম অর্ডার হবে, নাহলে হবে না।
উপরে দিয়েছেন তো হ্যাঁ, সবগুলো অ্যাপ্লিকেশন নাম্বার যেগুলো সেগুলো ওই তিনটে বাদ দিয়ে, যে তিনটে বাদ গেল তো নাম্বারস গুলো দিয়ে দেবে, নাম্বার সাচেন
নামগুলো দিয়েছি
তাড়াতাড়ি করে আনতে বলুন। এই এক মিনিট দাঁড়াও, এই
From combined monthly, item number 396.
This is a category scale of the primary teacher. The person has passed an order like this petition. In that matter, with a retired teacher, and here is in service teacher.
তুমি না না, এটা এই ক্যাটাগরির নয়, এই ক্যাটাগরি স্কেল অফ পে, এটা তো পেন্ডিং না।
Justice Radhasekhar Manta also passed an order at
That's-
page 73.
দাঁড়া।
The lordship will please.
Wait. Yeah. When your teacher training was completed?
Page 39, my lord. Page, page 39. 14th July 2011.
So you are entitled to from that date.
Yes, madam.
Page?
Page 39, madam. Bottom portion, my lord.
14 July.
14th July 2011.
With effect from Oh, you joined in 2006,
2006, madam.
but the course was completed in 2011. So you are satisfied if this is given to you from 2011.
2006, madam.
2006 you are not entitled to.
My lord, already passed an order.
Whatever may be. Appeal is pending.
Your lordship will kindly see at page 71. My lord, Justice Radhasekhar Mantha was pleased to pass an order. Page 71.
No, you are in service.
Yes, my lord.
Still you are in service.
Yes,
Very well. Then whether you are entitled or not, that is subject to the result of uh,
Next page, my lord, page 72, paragraph 6, my lord.
who is appearing for the state?
I am appearing for the state.
Tell me what is the appeal pending on this issue?
My lord, I am no instruction in this matter, in this appeal, but in this matter, DPSC Birbhum already awarded to A scale category.
Is it B-room?
Birbhum.
What did A category scale means? You are for the state or the council?
I am for the state.
DPSC B-room has not yet been served. Who is for B-room?
Sumita Sen.
Just copy of the petition, I have served, my lord. This is my affidavit of service.
You are saying that he is entitled to from, she is entitled to from 2006. Sub DPSC, otherwise this cannot
DPSC
be.
is the answerable authority.
But the DI of schools has said from the date of joining in the school. When you joined?
2001, I have joined. Thereafter, I have transferred from school. That's
You joined in 2001, and when you acquired the qualification in 2011.
I have admitted in that course in 2006, my lord, and thereafter I have obtained the certificate.
But the Jarkulas teachers who have completed 2 year such and such from NCT recognized before or after their entry in the service, provided in service teachers will be a category scale from the date of attainment of such qualification. Already possibly their entry of the school from their entry as primary school. Teachers completed 1 year diploma training. Appointed in 2005. You are 2001 appointed. So from the date when you obtained the.
Thereafter, I took admission in 2006 for
But what is this report? How the DI is saying that who have attained to a diploma elementary course and appointed as teacher on or before they shall be treated as trained teacher. Teachers in 1 year diploma, completed 1 year diploma and appointed after 2000 pad. I fail to understand how he is giving this. Read out the notification.
Complete honor, diploma, implementation, and appointment.
In inviting reference to your letter number such and such, subsequent, the following categories of primary school teachers shall be treated as trained teachers and they may be allowed A category scale of pay. Then classification. Teachers who have completed 2 years diploma in elementary education, DLED, from NCT recognized institute before or after their entry in service, provided in-service teacher will be allowed A category scale of pay before the date of attainment of such qualification of DLED from the date of. However, person already possessing DLED qualification before their entry as primary school teacher may be allowed A category scale of pay at the time of their joining of the post. Now, he has joined prior 2001 without qualification. So he will be getting the A category from the date when he will be joined, but the right, when he will be attaining the qualification. But what the DI is saying, it is clear from the memo, this memo issued by such and such, that the criteria of obtaining the para 3. Para 3 is saying teachers who have attained 1 and 2 diploma education state recognized institution and appointed as teacher on or before
31st December 2005 shall be treated as a trained teacher.
So, this is a situation after getting, obtaining training qualification who has joined on or after. One is before 2005, subsequently did, and one who has joined on or after with qualification. He has not joined with the qualification. How he is saying that he will be getting A category scale of pay? Have you applied your mind?
Yes, ma'am.
Good thing. Mr. Bosho, you don't come with a preparation. This is the instruction, handing over the instruction. Now, Mr. Bosho, the position is he joined the school in 2001. In training course, she was admitted in 2006. Ultimately, course completed, got in 2011. She is praying from 2006 as the date on his entry to this. The DI, by this instruction, is saying, no, he will get it. Where is Mr. Shopon Banerjee?
Election code number 35.
Ask him to come. Read this. what he is writing in reference to such and such to defend the matter.
Notification এইখানে
It is clear from memo number. Mr. Bosho, read it very carefully. It is clear from the memo number 2013 issued by such and such. Para 3 under above noted memo vividly stated teachers who have attained 1 year, 2 years diploma in elementary education from the state recognized and appointed as teacher. Therefore, after acquisition of qualification appointment on or before they shall be treated as trained teacher. In the instance, the petitioner was appointed in 2000 as assistant teacher, but he has not attained 1 or 2 at the time of his joining there. Hence, the petitioner is not entitled to A category. From the date of joining of the school and after completion of the training, that is up to with effect from 2006.
2013 completed result has been published 2013. He admitted in 2006, but result was published in 2013. So also he is entitled to 2013.
There is no chance. You are getting A category scale of pay now.
No. Your lordship kindly see, your lordship, whatever your lordship said, kindly page 44, my dear. The notification method.
Of 4th March.
4th March, yes, yes. 4th. Last portion, teachers who have attained 1 year, 2 year diploma in elementary education from
13 notification
and appointed as teacher on or before 31/12.
No. Who has obtained, bad English, obtained training qualification and appointed. You were appointed without qualification, is it not?
I have appointed without qualification.
Yes.
I took admission in the year 2006
And got the degree in 2011.
14th July.
What is the appeal pending?
14th July.
Appeal pending, whether which of the date? Because in
Content payment. Content. Appeal to kotha pending. No, which appeal lots? There is no appeal lots, I think.
Yes, sir. One appeal is pending.
Disposed of by judgment date of January 2025 or disposed of by a division bench. The said appeal has been by ordered to determine whether the constituent bench of this court, the matter was kept pending disposal MAT 7.4. The said appeal has been disposed of by judgment passed by the division bench by this court. Now, along the MAT to along with the division bench held that the person who complete their technical with the and are in 38 case may delay declaring the qualification not to note whether taken by the court holding the said division judgment what character of allowed players similar to if that the petitioner shall be to scale up pay with effect from 2006 and decided by the division bench and this court. The division bench Justice Somensen Lordship. Matter was heard Lordship. Thereafter, Justice Division bench passed the order. Thereafter, Lordship, another division bench Lordship, Justice Somensen. That Lordship, I am cited that interim order is there, Lordship. After Somensen judgment, second, first, second, second judgment. Somensen. আচ্ছা তারপর আরেকটা সোমেন তারপরে আরেকটা সোমেনসেনের জাজমেন্ট দিয়েছি যে ইন্ট্রি অর্ডার দিয়েছে 19 তারিখ এর ঘরে লন্ডন করতে 19 তারিখ স্বপন কোথায় আসছে?
স্টে হয়েছে, আসলে স্টে হয়েছে, এই 19 তারিখ থেকে এটা দিতে বলেছিল।
Yes, that's fine.
আপিল দিতে টাকা দিতে বলেছিল এটা আমি ডিভিশন থেকে অ্যাপিল করেছি, একটা স্টে
What is the appeal pending?
The appeal is stay, division bench, Mr. বিশ্বাস say, one appeal was pending before the division bench, stay of the Lordship Justice Jyotirmoy Bhattacharya, matter is fixed for the 19. তাই তো?
Pursuant to the order of the division bench of Justice Jyotirmoy Bhattacharya, he landed single judge, my lord, allowed a category scale of pay, my lord.
Allowed it is from which date? From the date of completion.
Last day of the, no, that was not specified in that act. That was only
for
only a category they are
but
entitled.
three differences there. One said 2006,
Second, three situations. From the date when the course was commenced, from the date when the course was completed, from the date when the result was published. The result was published, that is the notification of 2013.
Lots.
Now, I was given the understanding there is an appeal pending on the issue
Yes.
whether it
That
should
is
be
relating
from
to Mendipur. Mendipur, Purbo Mendipur Primary Council preferred an appeal. That.
whether it should be from the date of when the course was had commenced or from the date of the completion of the examination
or date of the result.
Publication of the result.
That let's say I am giving lots of
Giving that
days
type
of
of
Friday.
appeal, I also moved yesterday, my lord. The order was stayed, my lord, the fixed on A19.
Only one page, my lord, whatever I have said, page 74, my lord, Justice Radhasekhar Manta already.
That is single bench. ওটা হবে না, হ্যাঁ ঠিক আছে।
This is the order passed by this court.
Yes, your lordship
Whether you want to, you are getting a category scale of pay or not at present.
At present পাচ্ছেন আপনি?
If yes, from which date you are getting it?
Received. তো পিটিশনে বলেছেন তো পেয়েছেন কিনা দেখুন না।
Ascertain it, sir, ascertain it, then come, not today, not. Take back your instruction. সার্ভিস কেন দেবে? সার্ভিস তো আজকে দেওয়ার কথা, আগের দিন তো হচ্ছে নাকি? তাহলে সই করাবেন না, না ইয়ে করে ফেরত দিতেন? এটা next monthly list it will be there.
397 I am for the petition.
I am for the state, my lord.
Last revision, there was a direction to file a report by the district inspector of schools.
My lord, kindly consider this. লেখা আছে।
You see the report, instruction?
My lord, I am ready.
Last few lines.
First of all, I am not claiming pension.
No.
No,
Your
no.
gratuity, enhanced
Gratuity
gratuity
matter.
cannot be calculated because some
Yes.
papers are required,
Last paragraph.
which you are not supplying.
But kindly appreciate one thing. First of all, they never communicated any communication upon me.
So I'm
that
directing
this
you,
document-
I'm directing you to meet the DI with relevant papers.
My lord. Second thing is that they have already issued a PPA as per 2019 ROPA. So all the documents have been verified there and they have issued a ROPA. Now the question of subsequent verification will not arise because they will just revise my gratuity amount as per 2019 ROPA.
So revised PPO has been issued.
No, that is my prayer. That my
No, what they are, last line.
Last line. However, it is stated clearly.
Necessary steps will be taken up for sending papers to higher authority.
Yes. For enhanced gratuity in accordance with ROPA 2009, all the documents were submitted at the time of retirement.
There are no dispute. Go there, ascertain what are the new dispute. Ashwin.
My lord, on last occasion, my lord directed me to pay the deficit court fees which I have paid already, madam. And madam, this matter relates to Somrajyoti matter, ma'am, where the coordinate bench has already passed for giving appointment to the candidate.
তার মানে করছিস তুই, তাই তো? বলছিস তো? This matter is not.
According to say, board, the action is pending, my lord.
মানে 2016 they are মানে admittedly untrained candidate.
Some of them are having qualification of the batch of 2008 and 9. Some are having of 2007.
No, not at all. I have checked up. My appeal is pending, my lord, for the timing out.
এই তাড়াতাড়ি চলো না গোরা। Oh, that can be disposed of. দেখি
সকালে হয়েছে
সকালের অর্ডারটা হবে। কে করলো জানো?
কোনো ডকুমেন্ট না দিয়ে থাকে তুমি দিয়ে দাও তুমি ডেলি লিস্ট
Oh, these are the matters appearing. The similar matter. ওগুলো করে দিই, চলো ওগুলো ফেলে গেল। Mr. Chaudhary, today in the morning, give me that. তুমি করেছো তো?
Some matters never appeared in the list.
List কোথায়?
It is also not given in the.
Lordship, item number 25 and 27, which are appearing first, then you give me.
25 and 27.
হ্যাঁ
আজকে
টোয়েন্টি আপলোড করেছে 25
হ্যাঁ আজকে সকালে
এই লিস্টে এত মামলা ছিল।
দেখি
টাইম লিমিট দিচ্ছিলাম কিন্তু তুমি করেছো যেমন আমার ডকুমেন্টস না থাকে তখন কিন্তু আমরা পরে যেতে
আমি চলে যাই। মে আই টেক ইউর লর্ডশিপ লিভ মাই লর্ড? May I take your lordship?
I don't know if it's required, then I will.
Sir, I'm coming. Yes, sir.
Come back. সই করে দিই। কারেকশন ছিল তো এর।
হ্যাঁ গো
এই জন্য কারেকশন করেছিলাম।
এরকম করে মার্কিং করবে বুঝে করে এক করে ধরতে পারে।
ও একটা সেইট খালি না। এই Lordship. 399. Lordship. Then 400. Similar lordship.
401.
400 401.
Wait. Hey, এটা নামি না, please. 400. Appearance টা নিচে 400.
401.
Similar lordship. Any now state appearance 401.
I'm for the state, my lord.
Give appearance.
I have given, my lord.
402.
Similar.
Lord. এই ওকে দাও না, অ্যাপিয়ারেন্সটা দেবে ও। ওদিকে ঝুলিয়ে রেখে দেবে ওরা, নিয়ে ছিলে নিয়ে। Oh. 406. Anyone from the state? 406.
I'm for the board lordship. Similar lordship.
Board will do.
407.
Similar lordship.
408.
Similar lordship.
408.
I for the state.
Give your appearance. Give your appearance.
417.
Similar. And those matters which have not been listed, dissimilar, give me a list.
Lordship, item numbers 417. I don't have a copy. Kindly.
407.
17. 417 just.
17. Give him a copy, otherwise
The
he will
copy?
not be able to work out.
Yes, 70.
There will be a direction to supply particulars of the candidates to Mr. Chaudhary. Now, Gaurav.
আরো আছে।
প্রিয়াঙ্কা নস্কর দাদা ছিল, দুটো মামলা করে পালিয়ে গেছে, 13তে ধরে নিয়েছে।
For the state.
Lordship, the matter relates to 5% additional penalty of 2020. The matter which was Mr. Bhattacharya and Mr. Sannal was doing, it is fixed in the monthly list of March. Let it be in the monthly list of March.
March will not do. Because the fate of that matter will decide
Lordship,
the all other
the
matter.
2020 recruitment process 5% will be decided.
হ্যাঁ।
If that is decided, other matters will be decided.
এই এখন আউট অফ লিস্ট করো। হ্যাঁ। এদিকে আসো।
So 2006, matlab, hold on, matlab, 12/3/2010. Thereafter, matlab, her matlab, certificate was sent for verification. And after verification, 2014, she got appointment and she was asking for matlab, notional benefit for that period. But approval matlab, comes out on matlab, 15 January 2014. I have tagged with I have annexed the documents also.
But he was empaneled in 2010. She was.
But unless until her certificate, matlab,
He is
exempted category
responsible.
certificate from the national employee
He is responsible.
Responsible.
How?
Matlab, because matlab,
She has given an employment exchange card
matlab,
to prove that she belongs to exempted category.
matlab,
It is your duty to verify this document.
yes.
You took 4 years to verify the document.
Not only
For
the
that,
petitioner,
she will be.
other similar situated persons also sent for matlab, verification.
They will come one after another. Don't worry.
But unless until matlab, she got approval.
No, approval was delayed because of this lack of this is verification.
That is the
Give a
only,
formal exception. In compliance with the order direct.
I am for the board, Lordship.
Dismiss for the
petition, Lordship. It's a transfer matter, Lordship.
transfer.
Transfer.
From which
Single
school to
transfer.
school?
School is, Lordship, the district is Malda, Lordship, and the school is Holdibari Ranghat, Lordship.
That you have uploaded in your website. It is if it is in medical ground, what are required to be done?
The order.
Order.
Order. I have to check lordship because I have
Ask your president to upload it immediately.
I have already instructed them and sent the order also to
All
upload it.
DPSC must know if it is the ground is found to be false,
Lordship.
they will lose their job.
No, this is not medical, this is distance ground.
Distance, how, what is the
Guardian is old.
Your Lordship, also that my father is a old aged, is this is 2 grounds, Lordship.
Very old, na? What is the age of your father?
76, Lordship.
And what is your age?
My age, Lordship,
42.
42.
So you cannot travel. You want to go to your father. You leave.
17 joining,
lives,
19 confirmation.
Yes, Lord.
huh?
2017 joining, 2019 confirmed.
Where your father lives?
My father leave, Lordship. The address in my coastal, Lordship. This is my address.
Mothabari, Malda.
Mothabari.
And where your father lives? Father's address? Any proof of your father's address?
No, nothing is annexed.
That's not.
Nothing is annexed.
No, that address, the only for my address is annexed in the showing the coastal, Lordship. This is my home address and the school address is, Lordship. The page 12, Lordship.
Page 12?
Page 12 is the joining report, Lordship. The school address, Lordship.
Harba 2 circle.
Lordship. Harbour 2 circle.
You go to school from your residence or you stay in that Harba circle area?
Saying that information not.
Done.
এটা কোন হলো?
Every service.
But you have not raised that you want to live with your father. That you have not.
Lordship, but the distance show that I'm regular journey to my residence to my school, Lordship.
140,
140 kilometers is my school residence to my
one
school.
way or
One way, Lordship. This is
No, in the representation it is written
both sides,
70 kilometer durotto.
70 kilometers.
70, both sides 140.
Pay something to the council. 10,000 rupees to the council.
But
The
No, Lordship, kindly.
Pay something
Yeah,
to the
Kindly,
council.
Lordship, kindly request, but cost is
42
not.
years, hale and hearty teacher, you cannot travel 70.
Lordship, I agree, but cost, kindly, Lordship. Kindly, did not, Lordship.
1 month's salary, 1/3 or 1/4 of 1 month.
Eh,
Pay something for the children.
Lordship, kindly, cost. Kindly delete the word is cost, Lordship. Kindly, 10,000.
I'm deleting you, pay, I delete.
10,000 থাকবে তো
No, Lordship.
10,000, nothing.
Lordship,
Otherwise, you will not be able to prevent this kind of teachers to come to your chamber.
Lordship, kindly.
So next time you will made a cost us to this type of petitioners that if you go to High Court, get ready to pay something. 10,000 টাকা কেটে দিন. Next one.
I'm grateful.
Grateful. Individual service.
আর PTR is also deficit in this. PTR ও খুবই হবে না, PTR deficit আছে.
Tell your client that on your prayer, cost has been condoned.
ভিডিও তে দেখে নাও, ভিডিও তে দেখে নাও।
Shamik Chatterjee is appearing for the petitioner, my lord. My lord, he was in court after recess, my lord. He had to leave at the face of a family emergency.
Prayer, April, accommodation paid for, April. তারপরে
12, my lord, Mr. Oshin Banerjee for the petitioner, my lord.
Same order.
I check up, my lord.
Same order.
April.
My lord, in 413, my lord, I have to file the report.
I'm for the Kolkata Primary School Council.
Yeah, yes. Yes, yes. This is the copy. একটু দিয়ে দাও। My lord, envelope is torn because of that. না, এটা রয়েছে।
Are you showing the same?
My lord, no. What happened, my lord? Day to day, I am coming with this brief, my lord. Therefore, it is
Same envelope you are showing for every report.
No, my lord. My lord, the size of the envelope and it is written here. WP number. No. My lord, my submission is always, my lord, supporting with documents. এই যে WPA 362.
Last line of the report speak of that. No, the DI of school is not the competent authority.
তো ঠিক আছে। Deeply obliged, my lord.
414. My lord, I'm for the state.
Dismiss for default.
415. I'm for petitioner.
ঢুকলো কি করে এখানে? করে দিন না, ওই সে এতক্ষণ বসেছিল। Disposed of.
One hundred 16.
Yes, state response.
For the petitioner, trading for in service teacher. I was initially selected for my DLA trading, but subsequently deleted my name. But why his name has been deleted? He also directed the DPSC to file a report.
Supplementary affidavit?
Yes, supplementary affidavit. Why there was delay? Kindly see, I have explained why there was delay.
Mr. Mitro,
Lordship, my lord.
why his name was deleted?
Because, my lord, in the year 2023, 2024, a good number of primary teachers were recruited by South 24 DPSC as per recruitment process, and they are recruited as untrained primary teachers. And DEL ED training 2026 session preference has been given to the untrained teachers who have been appointed into 2023 and 2024 as per recruitment process 2009. Here is the petition number. This is my report. Your lordship, they have stated.
That I have already stated, madam.
No, that is what. But why
juniors
his
have been given preference?
No, why name was deleted?
So, my lord, I'll get back to your lordship.
Yes, get back. Really, narration of fact will not.
Can you see my report, Malad? I have explained.
No, DPSC would explain, my lord. What are you
From paragraph 4 onwards, Malad,
কে আছে রে ডিপিএসসি রে কে আছে সাউথ 24 পরগনা আছে
Oh, DPSC is a necessary part.
Yes, yes.
He was here. Last occasion, he was here.
গৌরব
Bhaskar Prasad Boisho Ranjan Shah.
Then my lord,
Then my lord.
I missed my lord.
I missed.
কি আছে?
কেন ওদের নাম এই করেছি কেন?
Arey, why you have deleted his name? You are supposed to explain it.
694 my lord it is.
No, 416.
416.
Let him take the DLED course.
Yes, Malad.
Is there any reason for exclusion of her name?
My lord, because of that,
Malad, I
my lord,
take
they are
admission in
the
the private institute also, Malad. I have
my
no
lord, they are the my lord for the purpose of my lord the previous year student all this for this reason my lord perhaps in this
Perhaps don't guess. When you are getting your last occasion, you were there.
my lord I shall come with the report.
I don't know what you will do. Either you may come
my lord
with a submission that we have allowed him or we are going to allow him, or you can object.
My lord,
My prayer is to allow me to undergo my
Your
training.
lordship wanted to
Yes,
know
my lord,
reason for deletion.
yes I shall come with the report.
He is working as teacher as untrained. He want to complete his training work.
My lord, several candidates are there. Therefore, my lord, I shall come with a report or instruction, whatever there, my lord, I shall mention why
Not
he
allow.
cannot.
Ultimately, they will be affected
Darao.
because of the NCT requirement.
Because of that, my lord, they have delayed their flight.
Whatever
Because
you
of that.
disclose,
My lord, I
that
shall disclose. Therefore, my lord,
Arjun,
let a chance be given to me, my lord.
you.
Lordship, then I shall, my lord, kindly extend the time, my lord. I think, my lord. Therefore, আমার এই জন্য মনে পড়ছে তো এটা আমি মিস করেছি এখানটায় দ্যাট ইজ অ্যানাদার থিং
Reasons must be there, my lord.
yes I have given the reason also.
Then let it be not today only, Malad. Let him come with the brief, Malad.
তোমাকে কপি দেয়নি
না আমার কাছে
আমার বিষয়টা নিয়ে দেয়
দাঁড়ান ওকে কপি দিয়েছি নাকি দেন আই শিল গিভ ইউ এ কপি ওই তো আই হ্যাভ গিভেন হিম এ কপি
এই রিপোর্ট
হ্যাঁ
যেটা জজকে দেখাচ্ছিল জজ সাহেব
ওটা যখন
This is nothing.
You come with better particulars.
না দাঁড়াও না দেখে নেই দিয়েছি তো।
Mr. Bari,
Yes.
this report is saying whatever, hence, what is hence? This was given to 2024-26 session.
No,
They
this
were
is-
recruited untrained teacher in 2024-2026.
No, 2002, my appointment.
This year chances has been given to them.
Since I was the single teacher of the school till 2012. But I
He
could
has not applied in time. This is the difficulties. And my lord, at present,
You are
we have,
not
my lord,
saying-
given
What your report
lordship.
is saying that preference has been given to the untrained teacher who has been appointed 23-24.
Yes, sir.
Therefore, you have given preference to them.
Yes.
But why not this candidate?
Because of that, he has applied, my lord, later on. He has to apply in the year.
My name was included in the list.
You are not. You have excluded because you want to give preference to the newcomers.
Newcomers.
But he is a she is a
Next year, my
teacher.
lord, he will be given in that event.
So submit, say it clearly.
My lord.
Say it clearly.
Lordship.
The
Application was issued.
And my lord, they have not applied. He has not applied.
Sorry.
When notification was issued?
বলো
Supplementary with need
বলো
is
কবে
তো?
notification
অনেক
issued?
অনেক নোটিফিকেশন দেওয়া
The
হয়েছে।
report of the
কবে
He appointed in the year 2001 as untrained
Sir.
candidate. My lord, I have
you have in your
understood, my
report,
lord,
you have said
my lord.
that you are giving preference to the newcomers. Very
Lordship,
well, give
lordship,
preference. But
lordship.
he must get
My lord,
a
my lord,
chance.
I shall come with.
পরেরটা গো।
Not any earlier date?
এটা কত নম্বর আছে?
We can
Wait until April, you can wait. ঢেকে যাও না।
এটা কত নম্বর আছে? এটা কত নম্বর আইটেম?
আরে দা- নেই কেউ চলে যাও 422
18 হয়নি 17 18 টা হয়নি
অব্দি আছে লিস্টে 18টা তো 460 পরিকল্পনা
বাট পেপার নট টু বাট হয়নি এটা
দাদা এটা
418 what happened? আছে তো what
পেপার নট
April 418 Sandeep 418 April accommodation paid for দাঁড়া
লিস্ট শেষ হবে
I am behalf of the petitioner. On the last occasion, you received direction to file report. So state responded also.
who will file report?
DI, respondent number 2, the state. Matter related to family pension, my lord. Unmarried daughter before your lordship.
But Mr. Bagh is not available today. Not today. Last 423 হয়ে গেল চলো